Yes, hello everyone, and thank you, Rita. So I will present briefly key points of the new regulation which applies to online sales. Previously, EU competition rules did not specifically address how online sales in the distribution chain should be regulated. But now there are new rules and also guidance or framework for assessing such sales which are online. Now, for businesses, the key takeaway is that there are some provisions or some restrictions which are hardcore and which are prohibited as such. And then there is a second time of provisions which needs to be further assessed, and it depends on market shares of the parties, it depends on objective or rationale behind the setup or the arrangement. But it is important to identify whether your specific provision, arrangement, assessment needs such a further assessment from competition law perspective. So what is important with this new regulation? Firstly, as I think already Kasyani has mentioned, new rules, they specify that although in commercial terms, those online agreements could be qualified as agents for competition law perspective purposes, these are not agents, and it means that also to those online sales, rules on pricing and on consumer allocations or territories also apply. The second important novelty is that new rules outline which online sales restrictions are always prohibited, and then they outline which online sales restrictions may be allowed if they are justified and if certain conditions are met. Thirdly, there are a number of rules regarding pricing, which I will speak about today, and also about active and passive sales, and I think Rita will further discuss this topic. So let's speak about this new concept. As there is a new principle that effective use of the internet by buyers or by buyers' customers cannot is not allowed, and it is a hardcore restriction. Now, vertical guidelines, they provide examples of what are those examples when a supplier or when a buyer or its customers are prevented from effectively using the internet. So such examples include, for example, when a supplier directly bans internet as a means of, as a forum for sale, when there is a ban to use online stores or entire online advertising channels, when suppliers require that online intermediary service prevents customers from other territories to view the online store, or when sales are terminated based on customer's credit card data, which would suggest that this customer is from the outside territory. Such a requirement in a contract would also be a hardcore restriction. Then such requirements as to sell only in physical space or only when physical personnel is present, these are also outlawed. But the guidelines and the vertical block exemption regulations, they provide that certain online sale restriction may be allowed. And this depends on the market share of both parties to this transaction and also on further assessment. So some online sale restrictions which relate to quality requirements or to some requirements that minimum offline sale presence is preserved, or that there is also a store besides an online sales channels. Such requirements actually may be allowed, but further assessment is needed, and there is guidance on how to assess such cases. Now let's speak about pricing, which applies to online sales. As previously mentioned, since for competition law purposes, in most cases, online stores, e-commerce, they would be characterized either as a buyer or as a supplier, those pricing rules would also in all likelihood apply. So Kasjani has already spoken about dual pricing and this new non-equivalence principle, saying that in certain cases, suppliers, they may set different prices for the same distributor for the sales online and offline, if it is justified, if it's not actually aiming to sabotage any of this online sales channel. And similarly, there could be different criteria applied to online and offline sales in selective distribution, again, if it is substantially justified. Regarding resale price maintenance, as you probably know, so the resale price maintenance, it's a situation when a supplier tells its distributor what prices to apply downstream to end consumers. This still remains a hardcore restriction, and as a rule of thumb, it is prohibited. However, what is interesting, the guidelines, they provide for certain situations when actually, if the supplier can prove efficiencies for this resale price maintenance, it could be potentially justified. And those cases include, for example, launch of a new product, or when a wholesaler constantly sells the product under the wholesale price and thus damages the brand of this product due to very low price, or in certain cases when there is short-term sales campaign, also fixed prices could be justified. So theoretically, that is possible. Those guidelines, they also now elaborate more on what instances or what conduct is considered to qualify as a prohibited resale price maintenance. And what is interesting is that also minimum advertised prices are qualified or considered to be a resale price maintenance case. And also the so-called fulfillment contracts. So here, those fulfillment contracts are contracts when there is an agreement between a customer and the supplier, and another party, another supplier fulfills this contract between customer and the supplier. And now it depends on who chooses this third party. If it is a customer who chooses this third party, then the supplier should not set prices for this third party, or that would be a prohibited resale price maintenance case. But if a supplier itself chooses this third party, then this in all likelihood would not qualify as such a prohibited resale price maintenance. Now the vertical guidelines, they also provided explanations regarding price monitoring software and price reporting. And as such practices to monitor prices, to report prices applied are not prohibited, but they could be prohibited if actually they are meant or they are enacted in order to enforce such resale price maintenance. So the takeaway here is that it's not prohibited to use those, but the aim of using such software and such programs needs to be assessed. On the last 2 points, which I wanted to make, refer to pricing comparison tools and to the so-called MFN clauses. So what the new regulation says is that suppliers cannot totally ban use of pricing comparison tools. However, they are allowed restricting usage of such comparison tools, and it depends on, again, it depends on market shares. So if this pricing comparison tool is widely prevalent on the market, in all likelihood, this would be anti-competitive, but certain restrictions or quality requirements could be allowed. And as a last point, there is new guidance on the MFN clauses. So MFN clauses are contractual clauses whereby supplier of goods or services is obliged to provide those goods or services at terms which are no less favorable than those the supplier provides to other competing companies to its downstream buyer. So what the new rules state is that when such MFN clauses are enacted in regard to online intermediary platforms, that is prohibited. But in other cases, when such MFN clauses are enacted, say in non-retail scenarios or in non-online sales channels, then subject to further assessment, actually, this could be allowed. So this ends my part of the presentation, and I would be happy to discuss this more in the Q&A.